in Muhammad Raja versus State of Bombay. The appellant came to India in 1938. He went on pilgrimage to Iraq in 1945. On return, he was registered as a foreigner and several times his stay in India was extended. In 1957, his request to extend the stay period was refused. He contended that he must be regarded as a citizen of India under Article 5, but his appeal was dismissed. The court held that though he was original resident, he did not acquire Indian citizenship because he did not have a domicile in India. When the appellant returned from Iraq, he took over the job of a cashier in a hotel. That by itself was held insufficient to establish that there was a change in his mind of the kind necessary to acquire a new domicile. His application was extending his stay in India made from time to time fortified this conclusion. The domicile of choice continues until the former domicile has been resumed or another has been acquired. The petitioners, who were foreign nationals, challenged the order of the central government expelling them from India on their failure to acquire Indian citizenship. The petitioners came to India before independence and were staying continuously on the basis of foreign passport and residential permits. They were engaged in Christian missionary work. They contended that they become citizens of India by virtue of Article 5 of the Constitution, as they were staying in India for more than 5 years immediately before the commencement of the Constitution. The court held that they failed to establish that they had an intention to reside in India permanently. The petitioner did not have their domicile in India. For the acquisition of a domicile of choice, it must be shown that the person concerned had a certain state of mind, the animus menendi. If the claims that he had acquired a new domicile a particular time, he must prove that he had formed the intention of making his permanent home in the country of residence. Residence alone, unaccompanied by this state of mind, is insufficient. Domicile of origin is lost only on acquisition of domicile of choice and not on mere continuous stay in other country. A minor or married woman is not independent person. Neither of these classes has the legal capacity to make a change of domicile. Therefore, the domicile of an infant generally follows the domicile of his father, while a married woman takes the domicile of her husband. A widow retains the domicile of her husband until changed by her own act. Stop.